Hello, and thank you for joining us today. In today's presentation, we're going to be going over the summary suspension of clinical privileges and how that plays into separations from government service, as well as how it might play into a reduction or revocation of clinical privileges. As always, whenever we have any of these types of activities, they're usually based on clinical care concerns, and so they may involve reporting to state licensing boards to the National Practitioner Data Bank. Clinical leadership and those who support the medical staff process at VA medical centers, as well as our colleagues in human resources, have lots of responsibilities. And among them, when it comes to professional practice issues, we have to remember that we're responsible to respond to unacceptable conduct or performance on the part of our clinical practitioners. We also have a responsibility, though, to afford these providers a due process if we're going to be doing a revocation or a reduction in their clinical privileges. And if they're a physician or dentist, we have an obligation to report that action to the National Practitioner Data Bank. And lastly, we have a statutory responsibility for reporting providers to state licensing boards in the states where they are licensed or have been previously licensed. So today we're going to take a look at some of the relevant terms and talk about all of these things and try to get our arms around them and understand who has roles when and what actions have to be taken. We're going to talk about a summary suspension of clinical privileges and what that actually means and what it entails. We're going to talk about professional conduct or competency. My colleagues in human resources talk about PCC, and when PCC is involved, it triggers an arena that brings it over to the medical staff process side. You might hear us on the medical staff side refer to it as CCC, or clinical conduct and competency. We also are going to talk about privileging actions and when we're required to report to the National Practitioner Data Bank, as well as under what circumstances we might be considering reporting to the state licensing boards. This chart actually is a nice summary chart. You might want to keep it handy, but it helps us understand what policy or regulation we refer to based on our issue or our concern and what we might do with it. So if you have a PCC or a clinical care concern, something that's defined as direct patient care or clinical competence questions, you're going to want to take a look at what triggers do we have, what trigger process is in place that we have to do. These types of things will frequently trigger the opportunity for a grievance or collective bargaining agreements. What are the things behind these activities? And in the case of a permanent Title 38 employee, an adverse action may trigger a disciplinary appeal board or a DAB. And this will be the ability to have access to a trained grievance examiner. If you have the case where somebody so substantially failed to meet generally accepted standards of clinical practice as to raise reasonable concerns for the safety of patients, this is what is the exact language that you think about when you're triggering a review that might be reported to the state licensing board. The policy guidance on that is VHA Handbook 1118. And I should say right now, we're going to get into all of these in much greater detail. This is just a nice summary chart to keep handy for your future reference. If you have somebody who has demonstrated substandard care, professional incompetence, or professional misconduct, those types of activities may trigger a fair hearing and an appeal process and result in a privileging action that might be a reduction or revocation of those clinical privileges. That you will be looking to VHA Handbook 1119 for your guidance on that. But before we even start many of these things, you actually might have a concern about the failure to take an action may result in imminent danger to the health of an individual. That's VHA Handbook 1119 again, and that triggers the summary suspension of clinical privileges. Sometimes these processes occur independently of each other, kind of like the pickets in a fence that hold up our fence. You know, each individual picket is very important to the process and to holding that fence up. Other times these processes become interwoven and they occur concurrently, and that's where we have a meshed fence. And we're going to talk about individual pickets and then also how they might overlap and intervene and become our meshed chain link fence. But first, let's go through the individual pickets, because we want to have a clear understanding of what the individual pickets are, and then we'll talk about how they merge together. The first thing that usually happens is something happens in your facility, and you've got a very serious concern. So you're going to take a summary suspension, because if the failure to take such an action may result in an imminent danger to the health and well-being of an individual. And the word individual is chosen very specifically because that individual can be a provider, the practitioner themselves. It can be a patient. It can be a patient family. It can be a visitor. So something has happened. It's triggering us to have a significant concern. So we're going to invoke the summary suspension process that's defined in 1119. The privileges are suspended pending a comprehensive review. We have no idea. We just have a trigger event, and we are going to have a comprehensive review now that may lead us to a due process for reduction and revocation of clinical privileges, or it may not. It may lead to other actions. But we want to make sure that we try to accomplish this activity in 30 calendar days. If you're in the private sector, a summary suspension greater than 30 days must be reported to the National Practitioner Data Bank. In VA, we don't report on day 31. But we really want to keep things moving in a very timely manner. So we actually want to try to complete this within 30 days. But if we can't, we just need to keep the provider apprised of our circumstances and our situation and when we expect to complete it. You want to do the summary suspension of clinical privileges for several reasons. First off, you're going to initiate a notice of summary suspension that you're going to issue to this provider. It's a letter, and it actually tells them what's happening. You're not in clinical care. We're going to do a comprehensive review, and you have rights under this process. So the summary suspension letter is extremely critical to this process, to conveying to the provider not only the agency's responsibilities and rights, but also the provider's responsibilities and rights. It does include a statement that if they are a physician or dentist and it results in a reduction or a revocation of their clinical privileges based on that patient's professional competency or conduct or clinical care concerns, and the summary suspension itself is greater than 30 days, both the summary suspension and any final action will be reported to the National Practitioner Data Bank after they have afforded all due process proceedings. And we're going to talk about due process, so I won't get ahead of myself there. You might initiate the process for a reduction or revocation of clinical privileges based on the fact that the clinicians demonstrated substandard care, professional incompetence, or professional misconduct. This is where there is substantial evidence, significant evidence that supports substandard care, professional incompetence, or professional misconduct, and that information is presented to the Executive Committee of the medical staff, who will make a recommendation that based on the information in the clinical care review, that there is a clinical performance and professional conduct problem here that should result in a reduction or revocation of clinical privileges. So that's our second picket in our picket fence. That, too, is found in 1119. I need to say at this moment that a separation is an automatic revocation of clinical privileges, and if that separation is for substandard care, professional incompetence, professional misconduct, then it entitles the employee to a fair hearing and an appeal process that is defined in VHA Handbook 1119. What is due process? Well, the due process is provided to the provider as a fair hearing. And if the individual is a probationary, a contractor, a temporary or part-time Title 38 without compensation, what's frequently referred to as an at-will employee, somebody who can be terminated on very short notice without any rights or appeal to the termination, they'll get their fair hearing process after they're separated from the agency. So we will give them notice of termination, we terminate them, and as we terminate them, we give them notice that they're entitled to a fair hearing if they request it. The non-probationary employees, the full-time permanent employee, the HR personnel action is actually combined with the clinical privileging action, so all of that due process is combined as well. and they will be afforded their fair hearing through that process, the Disciplinary Appeal Board, and we'll talk about that as well. The separate fair hearing and appeal is required if the privileges are just reduced and there's no adverse personnel action taken. It's very important, if you haven't figured out by now, that the human resources staff and the medical staff office professionals and clinical leadership need to be working together on these actions, because there is impact in the HR world on the actions that might be taken when you're doing a reduction or revocation of clinical privileges. So we want all parties at the table from the very beginning. And by all means, please include the regional counsel in these discussions, as they're the ones who have the legal expertise in advising us in appropriate information to include and how to include information in evidence files that we may be creating. In VA Handbook 5021, it describes the separation processes, and the procedures to separate these individuals are done as we are supposed to in our policy. If you have a full-time probationary employee, those are the individuals that are terminated after a summary review by a professional standards board. It might be called the Summary Review Board, a special PSB, but it's a group of people who look at the information that's being presented to them, and they will be then making a recommendation to the director as to whether or not to retain somebody during their probationary period or to separate them. The non-probationary full-time employee is entitled to advance notice, the right to reply, an opportunity to improve. If they are separated, if the separation is determined to be the action that the director wants to take, then the appeal is to a disciplinary appeal board, or they can file a grievance. And as I said, the temporary part-time walk contractors, those are at-will employees, so they are terminated at will. Their separation is very simple, and they're given their notice that they are terminated. Hybrid 38s are a little bit different. The probationary, whether they're full-time or part-time, they are normally not entitled to any due process procedures, and they're not really entitled to much more than minimal notice being given to them. The non-probationary full-time or permanent hybrid 38 is entitled to advance notice, the right to reply, and their appeal is to the MSPB, or an opportunity to grieve. The temporary employee is, again, an at-will employee, normally with no entitlement or due process procedures, and again, with minimal notice given. The questions often asked about reporting to the National Practitioner Data Bank under separation and termination notices. From an adverse action standpoint, the revocation or reduction of clinical privileges, VA only reports physicians and dentists to the National Practitioner Data Bank. VA's participation in the National Practitioner Data Bank is under a memorandum of understanding with the Department of Health and Human Services. And that MOU and VA policy states that we only report physicians and dentists to the National Practitioner Data Bank. We only report physicians and dentists to the NPDB after all due process rights have been exhausted. If there was a summary suspension as part of the process, and that summary suspension was greater than 30 days, then we report the summary suspension as well as the final action, the reduction of revocation, clinical privileges, to the National Practitioner Data Bank. A summary suspension alone is not reported to the NPDB from VA because it is not a final action. It's that temporary suspension of somebody's clinical practice in order for us to perform a comprehensive review and make a determination about the direction that we're going to go. I do want to say at this point in time, though, there are other aspects of reporting to the NPDB, and that is the reporting of paid toward claims. That's a totally different subject, and you will report any licensed healthcare provider whom you are notified should be reported for substandard care, professional incompetence, professional misconduct that's identified and resulted in a paid toward claim. We have other presentations on that I invite you to go listen to at another time if you haven't already listened to it. So for adverse actions, we report only physicians and dentists to the NPDB, and for paid toward claims, we report any licensed healthcare provider. We do have DHA Handbook 1118, which is our guidance and direction for reporting to state licensing boards. This is a process that's initiated when we have information that there may be substantial evidence that a practitioner failed to meet acceptable standards of clinical practice as to raise reasonable concern about the safety of patients. There is a due process outlined in the handbook that provides the employee with the opportunity to respond. The due process for reporting to state licensing boards is a paper process. They are notified to report. They are notified of the allegations or charges that will be reported, and they are invited to respond. Their response is included in the evidence file. Their responses must be mitigated into the original allegations or charges, and what charges, allegations are retained and what are mitigated. And that quote-unquote a mitigation memo is actually also included in the evidence file that is forwarded to the director for consideration of reporting, as well as the evidence file goes through. There are two channels through which the VISN can send the SLB evidence file. If it is not considered, as defined by the policy, a significant case, it can be reviewed by a privacy officer elsewhere in the VISN, not your own facility, to assure compliance with information law, the Privacy Act, because we are disclosing information to the state licensing board. They are the ones who will ultimately decide whether the information is significant enough that they want to open their own investigation and consider their own action. If the case is considered a sensitive case, it will be referred to the Office of General Counsel for review. Again, it's an information law review to make sure we've complied with all of our requirements of notice and evidence, and they'll let you know whether or not you have met that. But the sensitive cases involve if the provider practitioner has retained a lawyer, if they have a medical diagnosis, if there's been a death that is resulted in the case being referred or this provider being referred to the state licensing board, if there's media attention. Anytime that it's considered a sensitive case, the policy directs that the evidence file and the potential for reporting be reviewed by the General Counsel. It's only after the privacy officer or the attorneys in the Office of General Counsel have returned to you and concurred that it is appropriate to report this individual to the state licensing board will you actually move to the next step and make the actual report. It's a single notification letter, and then the state licensing board gets to respond back to you with appropriate authority, recognizing their appropriate authority so that you can release information to them. Again, that is a whole separate presentation that we have that we invite you to take a look at if you're involved in reporting to state licensing boards. The process for reporting to state licensing boards is initiated regardless of the type of appointment there is and regardless of whether or not there's a concurrent disciplinary action. So if there is a clinical care concern that meets the requirements of reporting to the state licensing board, we go ahead and start that process while we are going through other activities. It recurs independently of any sort of a privileging action you might do, so you need to be thinking about this process as you start down the road, and it might start with the beginning of the summary suspension. Oftentimes, the evidence file that's compiled for the action that is underway at the facility can actually be used for both the disciplinary process of a reduction or revocation of privileges and/or separation of an employee, as well as reporting to the state licensing board. But you want to keep both of these activities cognizant and in the forefront of your mind as you're building your evidence file and compiling your information. We do report to the state licensing board regardless of whether the person is a current employee or a previous employee, someone who has resigned or retired. DHA Handbook 1118 actually has a paragraph in it, paragraph 10, that requires a review of all licensed healthcare providers who leave your facility. There is no qualifier on that, all licensed healthcare provider. Everybody who leaves the facility must undergo at least the initial review and make a determination that there were no concerns when they left your facility. So you might want to go take a look at that paragraph. We've gone through the individual picket fences at this point, the individual pickets of our fence. We're now going to take an opportunity to really look at how they might mesh or become our Chainlink Fence. So if we reduce or revoke privileges because somebody demonstrated substandard care, professional incompetence, or professional misconduct, that individual is automatically entitled to due process. They have that right. Even if we're not going to report it to the National Practitioner Data Bank, even if they're a nurse practitioner who had privileges, a social worker who had privileges, if they had clinical privileges, anyone with clinical privileges, and we reduce or revoke those clinical privileges, they are automatically entitled to a due process. Because from that day forward, if we give them due process and the revocation or reduction is sustained, they must say, I had a reduction or revocation of my clinical privileges. If we don't afford them due process, they never have to make that statement. If we separate somebody, think about our at-will staff, the contractor, the WOC, the temporary. That separation is an automatic revocation of their clinical privileges. If that separation is for substandard care, professional incompetence, or professional misconduct, then we must afford them due rights. The due process under those circumstances is really just whether or not the separation was for substandard care, professional incompetence, or professional misconduct. In no way, shape, or form is it a due process for them to be reinstated as an employee at our facility. Due process that's not provided in combination with the personnel action must be provided separately. So if they don't get due process as part of their separation, then they must get due process separately, usually after the separation. And we have to remember that due process in one arena does not necessarily afford us due process in another. For example, that probationary employee who has that special PSB, they have an opportunity to speak to the special PSB and request that they want to keep their job. But that particular due process under the special PSB is not the same as a fair hearing as defined in your medical staff bylaws, where they are allowed to participate in the entire hearing. They are allowed to call witnesses. They are allowed to ask witnesses questions. So you can see that the due process in one area is not necessarily appropriate for due process in another. So only if it's specifically spelled out in one policy that it covers a specific area is it acceptable to accept that due process as the final due process. And in most circumstances, the only time that's acceptable is when it's a disciplinary appeal board for a full-time permanent employee. Remember that we only report physicians and dentists to the National Practitioner Data Bank. We don't report to the National Practitioner Data Bank, the physician and dentist, unless we have satisfied all due process. If there was a summary suspension that was greater than 30 days that resulted in a final action, we do report that physician or dentist, substandard care, professional misconduct, or professional incompetence, but we only report it after all due process has been afforded the provider. Even licensed independent practitioners who are not physicians or dentists must have that fair hearing and appeal process if we take a privileging action that reduces or revokes the privileges. We do it, as I said, even though they're not reported to the NPDB, because I'm sure many of you have seen questionnaires within our own facility as well as from state licensing boards and malpractice carriers and other healthcare entities where questions are asked of, have you ever had your privileges reduced or revoked? If we don't give them a fair hearing, we don't afford them due process, they never have to answer that question yes, because that revocation or reduction must be sustained through a fair hearing or an appeal process before they have to acknowledge it on any future applications. The steps for triggering reporting to the SLB are different than those for a separation action, but we still have to keep them in mind. We have to meet the requirements of information law and follow our processes before we report somebody, and we may be able to use the same information that we are using for any other action that we might have, and you can actually start the SLB process before, during, or after your separation. It can occur at any point in time. The difference, though, is we are basing our state licensing board reporting on substantial evidence. That is not as strong as the preponderance of evidence. Substantial evidence, both of our evidence is both substantial and preponderance. They're going to be more than 50%. They're going to be more strong than 50% rule, so that we know we've got some concerns here, and they're pretty significant. For reporting to the National Practitioner Data Bank and taking an adverse clinical privileging action against somebody, we need a preponderance of evidence. And that preponderance of evidence is supported through the evidentiary process, where we give them a fair hearing. They have their defense, they have their right to address any questions, cares, or concerns that are raised, and they try to mitigate the information. Substantial evidence is, we have a strong feeling we've got a problem here. We're going to share that information with the state licensing board. They will be the ones who will weigh the evidence, ask us probably for more information, open their own investigation, and they take the action. So you can see it's a little bit of difference, but either case you're going to have better than a 50-50 chance that the evidence is good and that there is a concern about this practitioner's practice. Okay, so we have established our pickets. We've talked about how they might relate to each other. Well, I want to get into a discussion now with you where we can apply some of this information and share with you some of the tools that are available to you through various websites. So let's take ourselves to General Hospital. Dr. Tracy, the Chief of Primary Care, received yet another disturbing complaint about Dr. Coleman, a probationary physician. This time the patient complained after ending up in the emergency room due to a severe allergic reaction to a new medication. The patient alleges that Dr. Coleman is overall arrogant and rude. We know we don't have anybody like that. And should have known about his allergies because they've talked about him. Dr. Tracy took a look at the patient's chart, and there's no information in the chart that such allergies were ever documented. And while at it, Dr. Tracy identified that there may have been some unnecessary tests and blood work in the case of this patient. So Dr. Tracy has to really stop now and think, what am I going to do? Oh my gosh, do I do an investigation, a focused review? Do I initiate disciplinary action or a separation? Do I summarily suspend somebody's clinical privileges? Do I initiate a review of the privileges and have the executive committee of my medical staff take a look at all of this and, take a process? I know, should I report to the state licensing board? All of these questions should be going through Dr. Tracy's mind. The answer? The answer is it really all depends. So it depends on whether or not we have a concern. It depends on whether or not there's any other information. Is this a single complaint or not? But in our case, Dr. Tracy decided that he would conduct further investigation into complaints received about Dr. Coleman because he has several. His review confirmed that there were numerous episodes of substandard care and conduct related to these deficiencies. So the chief requested a summary review because this is a probationary employee, so he wants a summary review by a PSB to determine if Dr. Coleman should be terminated during probation. In this case, the summary suspension of Dr. Coleman's privileges pending the review was also determined to be appropriate, given that the nature of the deficiencies created were imminent danger. So Dr. Tracy did complete an investigation, did have evidence, and decided that there was strong enough case to move forward with the Special Summary Review Board for this probationary employee to consider whether or not it was appropriate to keep somebody on staff or not. While this is all going on, he felt he had enough information as well to take it to the Chief of Staff and the Director to request a summary suspension of clinical privileges. The only person who can grant, reduce, or revoke clinical privileges in the facility is the Director. The recommendation goes through the Chief of Staff to the Director, and there are no committee meetings required for a summary suspension. So in this case, Dr. Tracy took it to the Chief of Staff and said, I've got a probationary employee here. I think we really need to take a look at the standard of care that this provider is providing us. I think we have an opportunity here because it is a probationary employee. that I'm not sure we can fix it in the time we have allowed, and I think we should just really think about termination, separation during probationary period. But I also have enough concern that I really don't think we want this person in care at this point in time. The Chief of Staff and Dr. Tracy will take that recommendation to the Director, and who can impose the summary suspension, and will also accept probably the recommendation to move to a summary review board or that special PSB. If you go on the Office of Quality, Safety, and Value website, which the link is given to you at the end of this presentation, under the adverse action piece in medical staff affairs, we have flowcharts, and they link to the employee relations website, and we're going to teach you today how to use these flowcharts. But this is a probationary employee, so that includes, you can also apply this to some of the temporary and part-time without compensation Title 38. So on the flowchart, there is a concern about the clinical practice or performance of this individual. It's determined that we do want to move to a professional standards board to think about separation during probationary period. At the same time, that dotted line is over there to have the facility think about whether or not during this process they want to impose a summary suspension. The summary suspension requires a written notice to the employee and would also apply that if there is a final action taken, that there is potential for a fair hearing after separation, as well as all of the reporting requirements. So in our case, the PSB recommended separation during the probationary period, the top green square. It was approved by the Director, and Dr. Coleman was terminated. That special PSB made a recommendation at the time of separation that it did involve substandard care, professional incompetence, or professional misconduct. And therefore, Dr. Coleman received a notice after the termination of a right to a fair hearing and potential reporting to the National Practitioner Data Bank. So as you see that top green box, the PSB made its recommendation to the Director, and as part of that recommendation, determined whether or not it involved substandard care, professional incompetence, professional misconduct. The Director accepted it. After the separation, Dr. Coleman was advised that he would be entitled to a fair hearing process, and this fair hearing process is only as to whether or not his separation was for substandard care, professional incompetence, or professional misconduct. The hearing in no way, shape, or form is for him to get a job back with us. It does occur after separation. So that means that you will give the separation letter, you're separated. A second letter will say you're entitled to a fair hearing. And be very clear that that fair hearing is only related to whether or not it was for substandard care, professional incompetence, professional. And that fair hearing, it should be defined in your bylaws, the process, as well as in VHA Handbook 1119. The post-termination hearing is only for the reporting to the National Practitioner Data Bank and has nothing to do with reinstatement. There are lots of different ways to take action, and a lot of the times if you were to call and ask for a consultation, one of the first questions out of our mouths would be, what's the employment status? We just had an employment with a probationary employee, an example with that. I want to go into an example now with a full-time permanent provider so that you can see that the process is different when it comes to these providers. We do have different flow charts, and we'll walk you through the flow chart here as well. So how it will work out in this one. In our second case at General Hospital, the Chief of Radiology has had some unprotected peer reviews performed by the staff radiologist, and finds out that Dr. Christina has made numerous failures with regard to properly reading X-ray films. Dr. Christina is a full-time radiologist who's worked at General Hospital for about 8 years, with no previous reasons for concern. However, the deficiencies of her work now are serious and numerous. Although this presentation is on adverse actions and separation, I'm going to take a second here and say that if this were the case and this were a single opportunity single evidence, previous 8 years have been fine. This might be where the chief of radiology would look at maybe offering Dr. Christina a focused professional practice evaluation, which would have clear expectations as to how performance could be demonstrated to be improving, that could go for 2 to 3 months, giving guidance and feedback to Dr. Christina throughout the process. But if it's so egregious that an FPPE or that opportunity to improve really can't be afforded to the provider because they're too numerous and too severe, then we would move into a reduction or revocation of clinical privileges. But it's very important to remember that we really want to take the opportunity to help our practitioners regain the quality that we knew they had before they came in and came to work for us. So that's where a focused professional practice evaluation could come out of this review that was done by the service chief and lead to an opportunity for Dr. Christina to improve the quality of her care and be reinstated to full practice and be a wonderful member of our medical staff. But if that can't be the case, then we would probably be moving forward. In this case, the supervisor identified that the performance deficiencies are significant and that they involve professional conduct or competency, that PCC of my human resources colleagues, or substandard care professional incompetence or professional misconduct. So the facility has to move into making a determination in our flow chart as to whether or not they should impose a summary suspension of clinical privileges. Remember, we do that when we have a concern about imminent danger to an individual. If removal is considered as part of a patient care concern or deficiency action in an independent practitioner, we can do it independent of the privileging and review action. We really don't want to. We need to be combining these. So if you have a clinical care concern that you think is going to lead to either a major adverse action, a reduction in pay, and or an adverse action that's resulting in a separation, human resources and the medical staff people need to be getting together right away and coordinating the activities, because we have obligations and responsibilities under our human resources regulations as well as under our policies and our bylaws. So we want to together assess and investigate the reasons for the possible removal. We want to provide evidence and facts to responsible officials who can ensure that we're complying not only with VHA Handbook 1119, but also VA Handbook 5021. If the executive committee of the medical staff makes a determination that it's not so egregious that they would want to reduce or revoke somebody's privileges, that recommendation would still go to the director. And if there are other issues that are not clinical care concerns, you could still have a separation, but it would not be for substandard care, professional incompetence, or professional misconduct. And therefore, it would be handled totally under the human resources activities of VA Handbook 5021 Part 2. This part of the flow chart shows that the recommendation could go to the director saying, we don't think that there's a privileging action required here. The director is the deciding official. They could decide to move towards separation on purely conduct or other issues not related to clinical care, or take another action, again, in accordance with VA Handbook 5021. There are opportunities to take action that do not necessarily involve the reduction or revocation of clinical privileges. But in the case of the ECMS recommending a reduction or revocation of clinical privileges based on substandard care, professional incompetence, or professional misconduct, then the employees issued a combined proposal for removal and a proposal for the revocation of clinical privileges. This will be true also if it's a major adverse action that's being proposed. If they are just proposing a reduction in clinical privileges, but that reduction in clinical privileges also is going to lead to a reduction in market pay, it would still be combined together, and the combined proposal together would go forward to the director to render a decision as to whether or not the proposed removal and the proposed revocation of clinical privileges should occur. If that there are reasons of substandard care, professional incompetence, or professional misconduct demonstrated, then the individual is, as we know, we've talked about several times, must be afforded a fair hearing. In this case, the fair hearing and appeal procedures are included as part of the appeal to the Disciplinary Appeals Board. So in the proposed removal and revocation letter or the proposed reduction letter for a major adverse action, the appeal would be made for a Disciplinary Appeal Board, and that letter states the requirements for submitting the request for an appeal to the Office of Human Resources and Employee Relations in VA Central Office, timeframes, etc. That office will manage the Disciplinary Appeal Board for this full-time permanent employee with privileges. If they're a physician or dentist and the Disciplinary Appeal Board sustains the removal, and that removal is for substandard care, professional incompetence, professional misconduct, then the facility will report the physician or dentist to the National Practitioner Databank. If it's a proposed reduction that resulted in a major action reduction in market pay, that reduction in clinical privileges would also be reported to the National Practitioner Databank following the Disciplinary Appeals Board ruling. We report only to the NPDB after we have exhausted all appeal processes. For a permanent employee, that would be the Disciplinary Appeal Board process. So to see how this fits into our flow charts, the ECMS, in our case, is recommending a revocation of Dr. Christina's privileges based on the finding of professional incompetence. So Dr. Christina is issued the proposed removal and revocation, and the director sustains it. So the bottom gray box, Dr. Christina, separated and her privileges are revoked. Dr. Christina chose to appeal to a DAB, and the DAB sustained all the charges. Their recommendation for sustaining the charges goes to the Principal Deputy Undersecretary for Health, and in this case, the Principal Deputy Undersecretary for Health concurs. That notification goes back not only to the provider, but also to the facility that it is sustained, and the facility will report Dr. Christina to the National Practitioner Databank. We're going to take a look at a hybrid 38 now. In case number 3, after many months of a consensual relationship between a patient and a staff psychologist, the relationship cools. At that point, the psychologist, Dr. Kiefer, informs the patient that he is going to start charging her, the patient, rent to live with him. The patient is a little bit upset about this, and with this new development, reports this to her current provider, who immediately informs appropriate management officials at the VA. We are assuming that the patient was a patient of Dr. Kiefer, and that at some point management of the patient was turned over to somebody else, and or maybe the patient had a primary care provider that she reports this to. But in any event, we have a problem here. So we have a hybrid 38, the psychologist is privileged. So the supervisor has identified that there's an issue with this hybrid 38 performance and conduct deficiencies that may involve professional conduct or competency, or in this case, probably professional misconduct, to fit our definitions that we look at on the clinical side. So the facility has to determine whether or not they're going to impose a summary suspension of clinical privileges, and if they make that decision, they do all their reading in VHA Handbook 1119, they look at their medical staff bylaws, follow that information, and make a determination. If the executive committee recommends not to reduce or revoke the privileges of the provider, but because it is a conduct issue that is inappropriate, they would propose a separation in accordance with VA Handbook 5021, Part 1. The director can accept that or not, maybe take another action, or impose the separation. It would be up to the director as the deciding official which direction to go on our flow chart. In our case with Dr. Kiefer, the executive committee recommends a revocation finding on the professional misconduct. So Dr. Kiefer has proposed both a removal and a revocation, and the director sustains and separates Kiefer is notified of his right to appeal to the MSPB, unlike Title 38 physicians and dentists and other Title 38 LIPs, the MSPB does not determine whether or not the charges are a result of substandard care, professional incompetence, professional misconduct. They're really looking at the HR piece of it and whether or not appropriate due process was provided under the human resources processes. So do not afford Dr. Kiefer a fair hearing until after you hear from the MSPB. Wait for the MSPB to make their ruling on whether or not Dr. Kiefer's separation is sustained. If the separation is sustained, then you send Dr. Kiefer a letter and he is afforded a fair hearing and appeal of the revocation of his clinical privileges. So that was a critical piece to remember. Please remember that if it's an appeal that goes to the MSPB, then you want to make sure that you wait until you hear from the MSPB before you afford the individual the fair hearing for the revocation of their clinical privileges. In case number 4, we have the director of a CBOC who cannot help to recommend the renewal of privileges for Ms. Dante, a nurse practitioner. Nurse Dante has obviously made numerous errors in her medication administration, and there are concerns with the prescribing practice. Due to the lack of a recommendation from the service chief, who is the CBOC director, the executive committee of the medical staff actually recommends a non-renewal of her privileges, and the director actually approves that action. So here we have a non-renewal of an LIP, Title 38, with clinical privileges. The supervisor has identified the problem. The facility needs to look at whether or not they're going to determine whether or not to give a summary suspension of clinical privileges while they're going through the processes that they need to do. If the recommendation is made by the executive committee to not reduce or revoke the privileges, they could still have other issues related to her competency that did not really impact on her patient care, and they could follow VA Handbook 5021 and Part 2 and move to a separation, or the director can take another action. I know the CBOC director had concerns about her medication administration or medication management, but it could have been due to timeliness, and the ECMS determines that there were not significant impacts to patient care, but they felt that her conduct, maybe she was down sleeping, and that's what it led to the problems of not being timely with patients, not completing medical records such that prescriptions were filled and completed, et cetera. So there are lots of factors that need to be looked at. But it would probably be rare that the ECMS would not recommend a reduction or revocation of her clinical privileges. If the ECMS recommends the revocation of clinical privileges, which we were all pretty sure that they would, in this case with Ms. Dante, they will issue a proposed removal as well as a non-renewal of clinical privileges. The non-renewal of clinical privileges or the denial of clinical privileges of somebody who has worked with you and has had privileges previously becomes an adverse action. It is the non-renewal or denial of clinical privileges is the same as a reduction or revocation process. So the director is going to decide in this case that Nurse Dante is fine as a registered nurse, but not as a nurse practitioner because of the controls over the registered nurse status. They have a place. They don't necessarily, if they didn't have an RN position or they did not feel that she was warranted to go to an RN position, they wouldn't have to do that. In this case, in our example, the director does decide to oppose a reduction in basic pay and reassign her as a staff RN, which is based on that non-renewal of clinical privileges, so it is managed as a revocation of clinical privileges. This is an adverse action in both the HR arena as well as the medical staff arena because we've had a major reduction in her basic pay. So Nurse Dante is assigned to the staff RN position. Her appeal process is going to be to a disciplinary appeal board. So she is going to make that appeal. The DAB sustains all the charges in her reduction in pay. The Principal Deputy Undersecretary for Health concurs, and the notification goes back to the facility. But no further action is required as far as reporting the nurse practitioner to the National Practitioner Data Bank. Remember, because we don't report to the National Practitioner Data Bank nurse practitioners. But what this slide is missing is it does not say whether or not you should be reporting somebody, Nurse Dante, to your state licensing board. We had a case several years ago within VA where we had it was an RN, not an APRN, who had issues with her medication administration. And while the facility was pulling together all the evidence and information for potential reporting to the state licensing board, it took them a little longer than it probably should have. But they moved her from an acute care unit to the community living center. And in the CLC, she had no problems. The lack of pressure and the responsibility that she was afforded, it was different. It was less. So when she was reported to the state licensing board, she was actually reported for her medication management problems, medication administration problems on the acute care unit, but there was also evidence in that file that went forward to the state licensing board that said that she did fine in the CLC, and it even included her statement that she had identified that she was much better off working in a less intense area. So with Nurse Dante here, we would still probably be looking at and considering reporting her to the state licensing board because we do have issues and we've taken her out of practice as a nurse practitioner, and we probably need to advise her state board who has her as a nurse practitioner of such. There are other types of Title 38 separations that are identified in VA Handbook 5021 Part 4 that are really not part of today's discussion, but I want to make you alert to them so that you'll know where to go look for them. That could be a separation for a disability. The failure to meet statutory and regulatory requirements is probably the one that I encounter the most, and those are people who have only a single license and it either ends up with some sort of a restriction on it or it's suspended or whatever the case might be. They're not meeting our statutory or regulatory requirements for appointment, so they're separated under VA Handbook 5021 Part 6. We may have pre-employment suitability separations and abandonment of a position, or somebody who lands up on the HHS Office of the Inspector General list of excluded individuals or entities, the exclusionary list. When any of these things happen, my advice is please go to Human Resources, please speak with the staff over there as quickly as you can, and work with them because all of these separations will be under 5021. That said, all of these types of separations do not eliminate the need for you to take a look at VHA Handbook 1118, paragraph 10, that requires you to look at all licensed healthcare providers who leave your facility to determine if they meet reporting requirements to the state licensing board. I know it sounds like it's not a very pleasant thing if we've got somebody who we are separating for disability, but if that separation is such that it really interferes with their ability to practice safe healthcare delivery, we need to advise our state boards of that. Somebody who abandons positions, we need to advise our state boards of that. So, like I said, one of these separations does not necessarily relieve you of your obligation to look at VHA Handbook 1118 and potential reporting to the state licensing board. Regardless of the way somebody is separated into the human resources world, we always have our obligations and responsibilities for fair hearing and appeal processes under VHA Handbook 1117 and 1119. That's reporting to the NPDB and fair hearing and due process for a reduction or revocation of privileges for those employees who must be afforded that obligation. So if we take a privileging action, doesn't matter whether we separate them or what or how we separate them, we have to make sure that we meet our obligation for fair hearing and appeal. That notice of a fair hearing may be separate from the termination process. It may be a separate notification, and in most instances it will be a separate notification. The only time we can combine it is when it's a major adverse action that is also combined with a major HR action that's going to lead to appeal through a disciplinary appeal board. Additionally, we have to remember that regardless of how we separate somebody, regardless of what action we take, we also must remember our obligation under VHA Handbook 1118 when it's applicable, and that is actually a statutory obligation. These are some references for you. The flowcharts and the sample letters that my colleagues in Employee Relations have posted are fabulous. They're there on the Employee Relations website. You get a flowchart, and at various points where you need to give notice to the provider, they will provide sample letters as to actually what to include. There is magic language that needs to be in all of our notifications. Physicians and dentists in all of our summary suspension and adverse action letters must be afforded notification of potential for reporting to the National Practitioner Data Bank as well as the State Licensing Board. All other healthcare providers for whom we're providing notice of a privileging action get the paragraphs related to reporting to the State Licensing Board. Thank you for your attention. I appreciated talking with you today. If you have any questions, please feel free to email them to vhacreditpriv@va.gov. We'll be glad to respond to you, and we'll be glad to offer you any assistance we can. Thank you very much, and have a great day.